Good evening. This is Laws 12062 Alternative Dispute Resolution. John Milburn. This is week 11, and this will be our final Zoom session. Our take-home examination is released on Sunday. At this stage, I expect that the exam will be released in the early hours, well, as early as I get up on Sunday morning. You'll have quite a lot of time to do that examination, and it is an examination where I hope you will contact real-life providers and provide some realistic timeframes and cost outcomes for your potential client or clients. We'll speak a little more about that later, but for the start, tonight's topic is the future of alternative dispute resolution. It's based on Chapter 9 of Spencer. But before we make mention of that, I want to share with you some comments that I picked up through NADRAC, and it's to do with the topic of prevention of disputes. Now, this might be relevant for the mindset that you adopt for the take-home examination, because you'll need to provide clients or the client or clients, I guess with holistic advice. You've probably heard me say that if you've done other courses with me. I'm really looking at the big picture. I'm looking to see if you can come up with a way to achieve a favourable result for your client. And that, to some degree, means that I think you need to coach your client a little bit to go into the ADR process in the appropriate way. So coaching your client, I think, is something that you would probably want to consider in the take-home examination. And what are some of the key points? Well, you'd need to, in asking your client to embrace ADR technology, get them ready to go into some form of ADR procedure. And in doing so, ask your client to be open to other points of view. Remember that the philosophy that what we're trying to do quite often in ADR is move a person, in this case your client, from a position to an interest. And an interest sometimes means being open to the other side's point of view so that you can work on something together as a joint interest, if you like. So that means making sure that your client is aware that everyone will need to have an opportunity to communicate his or her points of view in a respectful manner. It's very important that you speak to your client about listening skills and active listening skills and really trying to understand the other's points of view. So while in an adversarial litigation, we may not be terribly interested in the other's interests. We might be interested in their position, not necessarily their interest. Different considerations apply, and therefore a different mindset for you and your client at that stage. So NADRAC suggests that people think about others involved in the process as equal but different. And I think that's a really good phrase. So you need to accept that some or all of the needs of other people involved need to be considered. So when you're speaking to a client, NADRAC suggests that you do a couple of things. Firstly is listen. Listen for what you have in common. And that's a really good place to set a platform for a resolution. And during the mediation sessions that I saw, and there was a lot of really good work in this regard, as soon as there was a point of agreement, the good mediators would pounce on that and say, okay, well, we're making progress. We're agreed on that point. Let's see if we can move on, find some other points of agreement. Also, you need to think about whether your client is prepared to acknowledge that he understands or she understands the other's points of view. So some training there might be important in that regard as well. And the way in which your client responds to certain things will be important as well. So if you go into a mediation session, I think you need to coach your client to do certain things and not do certain things. So some of the things that they might do after listening well is be a little more amicable in your language. So instead of I want or I have decided or I am going to, try and soften it and coach your clients to do this. Use words like I think or I'd prefer or I wonder whether we could do this. And you may end up having a much easier resolution of the dispute if your client is prepared to adopt some of these principles. Some of the things that you want your client to avoid in an ADR situation is making threats or indeed reacting to threats or demands. So there's a little bit of that counselling and goes on to ensure that your client is acting appropriately. The other thing is that your client doesn't want to be in a mediation session and be accusatory right from the outset. And sometimes, words like you did or you are tend to lead to blaming situations rather than allowing that person to focus on the problems and dealing with behaviours appropriately. And also, making conclusions, obviously you are going to do that, or you are going to do this, or obviously, but that type of language can really create an impediment to good and worthwhile negotiations, particularly perhaps in a family law situation or a situation where you've got friends involved. You want to try and soften things and coach your client. And I think that's an appropriate strategy to consider before you go into an ADR session. Are there any questions about what I've just raised? Do people think that it's inappropriate for a lawyer to be involved in that sort of, as I say, more holistic approach? All right, well, we might move on then. Now, the future of dispute resolution, I'm going to talk about that briefly. This is really based on Chapter 9. And Sarah says, yeah, it's in the best interest of the client. So I think we need to consider ultimately what is in the client's best interest. And they might thank you for that at the end of it. After the end of a successful ADR session where they now have that enormous relief, this matter is now finished, they might thank you very much for coaching them to soften their approach and be more open-minded in the way they go into the session. All right, so the future of dispute resolution. The first thing is that specialist bodies are now creating their own processes. And I'd like to show you two things from QCAT, which I think are particularly interesting and useful from an ADR perspective. To do this, I'm just going to share my screen for a moment, and you should see shortly, if not now, Practice Direction number 1 of 2012, QCAT, in relation to hybrid hearings. So I trust you can all see that. All right. Hybrid hearings, I think I've mentioned to you, are a way to resolve matters in a very speedy manner, still allow the parties a considerable degree of control in the process, but ultimately come to a resolution of the matter. It kind of works like this. In a hybrid hearing situation, for example, to do with, say, animal management cases, where there needs to be considered an order for a destruction of an animal. It may be that the dispute hasn't been resolved through ADR processes, but we need to get this thing done. We need to get a resolution. A hybrid hearing essentially is set up like a hearing. The member hears the matter, and then at the conclusion of the evidence doesn't announce a decision, but rather writes a decision. That decision, which is written, is put into a sealed envelope, and the parties then go through a process of mediation. And as I've mentioned before, in this scenario, the mediation session is done as a pure mediation. There's no providing advice or anything of that nature. And the idea is this, that once the parties have heard all of the evidence, they're in arguably just as good a position as the member who's about to make the decision to come up with a decision. And it provides them with one last chance to try and sort out the issue before a decision is imposed upon them. If at the end of that mediation session the parties are unable to come to a resolution, then somewhat ceremoniously the member will open the envelope and announce the decision, and then it's binding. But until such time as that decision is actually formally announced, it is not made, even though the decision is sitting inside an envelope. So that could be an appropriate thing for you to consider recommending to your clients to push for if QCAT is involved. But just remember, of course, that just because it's a QCAT model, that doesn't necessarily mean that you can't use it in a wider context, because QCAT can only be involved in circumstances where it has jurisdiction to hear the matter, and even then, the QCAT may not decide to do a hybrid hearing. In practice, they're used only in certain specialised circumstances. So the reason I'm showing you that is that some tribunals, some courts, some bodies have their own special processes, and that's kind of the way of the future to some degree, but it's also very inventive. And when you're thinking from an ADR perspective about possible ways to resolve a matter, then creativity and coming up with something new is always a good idea. So if there are any questions on that, please let me know. Having said that, I'm trying to see where the chat facility comes in. I can see it now. All right. So I'll just show you another example through QCAT, and this is to do with expert conclaves. This is a procedure adopted in circumstances where there are likely to be experts called from both sides. And before the hearing, the experts are ordered to engage in this conference process between experts. We call it an expert conclave, and it's essentially a private meeting between the experts in the same field of expertise. It's chaired by a member of the tribunal, and lawyers, advisors, and clients are not permitted to attend. The idea is that without having to be seen, if you like, as supporting the way your client wants you to go, the expert is totally free in this environment to engage in a frank discussion with another expert. And the idea is that between them, the experts come up with areas of agreement and areas of disagreement, and importantly, the reasons for the disagreement. It is a procedure which enables the parties to get to the heart of the matter quicker at a trial situation, and rather than the court or tribunal necessarily hearing the full evidence of the experts in a hearing context, the tribunal will then hear, this is what is agreed, this is what is disagreed, and this is why. So it speeds the process and potentially makes it much cheaper as well. So that's a procedure which is quite new. It's been adopted at QCAT, and it's a very good way of dealing with issues that may have some technicality about them. Again, it can only be used in the context of QCAT matters, but that doesn't mean you can't borrow it in a wider context, and you might need to consider some of the options in that regard. I'll just stop the share now for the moment. Are there any questions from that? Okay. All right, so the point there is that specialist bodies come up with their own procedures, and if we're talking about the future of ADR, then different ways to do things tailored to a certain outcome or tailored to a certain dispute type may be relevant. There is, of course, the issue of technology, and now technology is going to have it's going to have a big influence on the way in which matters are resolved into the future. So it provides a platform to enable you to embrace a multitude of different ADR options. And you saw that during your recorded sessions. In some instances, the parties were in remote locations, and hopefully you found that it was a way of actually trying to assist in an ADR process using technology to good advantage. But as indicated in the text, there are different novel ways to resolve matters, such as the blind bidding procedure, where through technology bids are made and counteroffers made. That blind bidding procedure is probably more suited to an adversarial negotiation model than anything else. Let's see if we can think about how that might be adopted in practice. Let's say you have two partners in a business. One wants to buy out the other wants to buy, so they both want to buy out each other. How do you resolve the dispute? Well, one way perhaps is to set up some sort of blind bidding procedure where, having set the parameters, having set the contract as if one is going to buy from the other, what you do is allow the parties to insert a price and come to an agreement that whoever inserts the higher price will be the successful buyer, and the other party will be compelled to sell to that person at that price. So it's just an inventive way of trying to resolve the issue.
John, could I just ask, how does that differ from just a plain straight auction?
Oh, it's an auction, but only two parties involved are allowed. So it's a closed auction. It's not a public auction. And that may be seen as a suitable way to resolve, let's say, a family dispute situation in a family business where they don't want outsiders involved. They want to keep the business in the family, but the two siblings are just at loggerheads and they cannot work together. And they can't even agree on who's going to buy out the other one. So we say, okay, well, we'll create a mechanism. We'll see who wants this business more than the other. And you put in a blind bidding procedure in place to make that happen. So I hope that explains, John.
Yeah, thank you.
Okay. Thanks for that question, John. So that's just an example of some inventive way to assist the parties through an ADR process to resolve an issue. In the text, there's also reference to conflict coaching, which provides a positive atmosphere and a way of resolving disputes, but also to prevent disputes into the future. So part of your brief may be to resolve a dispute now, but also build in a mechanism that will work into the future. And some sort of conflict coaching may be the way to go in that regard. So these are just different models, just different new ways of approaching things, completely different to the adversarial litigation model that lawyers like me were trained to pursue in law schools through the 70s and even the 80s. So it's all very different now. Can we just take a moment? I'm just interested if anyone can come up, just through brainstorming, just a few words about your own model on any topic. Can you come up with your own new novel way to assist or to build on the bank of ADR options that are available now? Maybe I'll just start one. How about setting up a short form mediation session model where parties are set up in a room? It's meant to be for a day, but the parties agree that during the day they will come together and meet for a maximum of 15 minutes every hour. And for the other 45 minutes, they then go back to their advisors, they consider options, then they come back into a joint session. So the actual time for the entire mediation session is set, and the times when the joint sessions are set, and there are no separate sessions with the mediator, for example. So that's just a different model that might be useful in different circumstances. So has anyone come up with their own model, their own brand new way of doing things? This might be useful for the take-home exam. Come up with your own. Along the same line, says John, a timed conciliation. Yep, so just setting something different. Are there any other brand new models? Could be to do with anything. Could be criminal law, civil law, family law, neighbourhood disputes. It could be to do with a dispute regarding a multi-million-dollar construction contract. We've got nothing. We're coming up with nothing. So, oh, Sarah said one. No, John come up as the only one with something so far. All right. Well, something to think about. If you think of something over the course of finishing this session tonight, please weigh in. The next thing I want to do is talk about ADR and criminal law procedures. I'm just going to go to gallery view for a moment and see who's there. All right, welcome everyone. Okay, so ADR and criminal law procedures. Firstly, case conferencing. What I want to do, I'll just tell you, looking ahead, case conferencing, children, drug matters, stalking, justice mediations, domestic violence, and peace and good behaviour matters. Okay, so The first one, case conferencing, is, if you like, a catch-all. Since the Moynihan reforms in 2010, the process of negotiating at the magistrates' court level has been formalised, and the thing that we always used to do is now, I suppose, authorised. And when I say it's authorised, I mean by this that there are certain procedures which are set, and in that set procedure, defence and prosecution have an opportunity to resolve the issues without necessarily the matter proceeding to court, or if it does proceed to court, to do so on a certain basis. It may be that charges are amended, it may be that certain charges are dropped, it may be that all charges are dropped, or it may be that there is an agreement as to the facts, the material facts that will be presented to the court. So there's a whole lot of different types of conferencing, ADR if you like, that can take place between prosecution and defence within that prescribed procedure of case conferencing implemented as part of the 2010 Moynihan reforms. Different courts in Queensland adopt their own different methods, as do different lawyers and different prosecutors throughout Queensland. The model which was implemented really applies in Brisbane, and as I understand it, it operates Brisbane essentially to the way in which it was set out. I can say that in Hervey Bay, we don't use that model. We have our own special way of doing things, and essentially the court is aware of the way we do things. Most of my case conferencing is done by exchange of emails and then relatively informal discussions at the court. The model itself is designed to allow for participants to be actually in a sit-down type context, but we haven't adopted that practice where I am. Okay, so then we've got the next one is children. Shootout at 10 paces. Thank you, John. That is a different option. It's a little old-fashioned though. So I'm just inviting people to come up with their own novel ways of resolving a dispute without going to court. And John has come up with another one, shootout at 10 paces. All right, children. Children and the ADR process in a criminal law context. We've talked about this before. Youth justice conferencing is a platform that can be used to resolve disputes. At the moment, it is available only through police referral. The courts can't refer young people to youth justice conferencing. They were able to, but those options were taken away from the courts, but they're going to be reintroduced, as I understand it, in the not too distant future. But look, sometimes matters that are already in the court system, either at the magistrates court level or the district court level, which we call Children's Court of Queensland or CCQ, the matters could be referred back to the police with a request by the prosecutor for the police to undertake the youth justice conference process, and that is done in exchange for the prosecutor offering no evidence against the defendant in court. Now, have I explained that too quickly? So I'll just go through it again. If you've got a child, the child could be referred to youth justice conferencing by police, matter doesn't even go to court. Alternatively, when the laws change again and we go back to a system we had a few years ago, the courts could refer the young person to a youth justice conference, either indefinitely or not. But the third way of doing it is, if the matter is in the court system, through negotiation, through ADR, the prosecutor could direct a police officer to send the young person to a youth justice conference as part of an agreement, and part of that agreement is that the young person goes to youth justice conference and the prosecutor does not offer any evidence against that young person in court. Hopefully that makes sense. But such a procedure does require the young person to admit the crime to be eligible to attend the conference. Okay, if there's any questions on that, please let me know. Now, drug matters. If a person is charged with certain relatively low-level drug offences, such as possession of a drug or possession of a thing or a utensil, or perhaps a needle charge like failing to take reasonable care or failing to dispose, that person may be eligible to undertake a drug diversion program. It can be a diversion by the courts or by the police. Once again, the defendant must have admitted guilt, and defendants are only eligible in relation to circumstances where they do not have a disqualifying offence. So if someone has a conviction for certain violence or offences of sexual nature, or matters that were dealt with, drug matters that were dealt with on indictment, then they're not eligible to apply for a diversion, for drug diversion. And you only get 2 shots. You get 2 chances at drug diversion. So that's for any adult. And there was a previous question from John about the age for children, anything to do with the Children's Court. So if they're 16 or younger, they would be eligible for the Youth Justice Conference program. If they're older than that, they're an adult. Okay, so are there any questions about, just briefly, the way in which the drug diversion program works for adults? Okay, the next one is stalking. Might seem a bit odd, a bit specific, but in stalking situations, it is possible to avoid going to court and to have the person diverted, dealt with by way of a restraining order. And my apologies, the reason I'm going slow is I'm looking for something that if I can call it up on the screen, I will do so. No, it's not coming to me, sorry. But essentially the idea is that a person could be subject to a restraining order under section 359F of the Criminal Code. And what that means is that instead of the prosecution proceeding for the stalking charge, the court can impose a restraining order, and the court can impose that restraining order for stalking in relation to matters where the person is found guilty or pleads guilty, or prosecution takes some other action. So that other action might be offering no evidence. So in your negotiations with prosecution, you can offer for your client to submit to a restraining order if prosecution offers no evidence against your client and the court is willing to make the restraining order in those circumstances. So it's a very good way of ensuring that your client doesn't have to suffer a trial, saves a lot of money, doesn't have a criminal conviction for that particular matter. The penalty is they are subject to a restraining order, meaning that for up to 2 years they can't, for example, have contact with the person that they're alleged to have stalked. Okay, I hope that makes some sense. So it's another way that diversion programs and ADR can be used in a criminal law context. The next one is, and this is a very broad one, justice mediation. Justice mediation is essentially criminal law mediation, if that makes sense. So we're familiar with the typical mediation services that might be provided to assist people that are having a dispute about, I don't know, a neighbourhood dispute, noise issues. Go to the local dispute resolution centre and say, I've got a problem with my neighbour, could you please set up a mediation? Well, the same thing can occur in relation to criminal matters. And a person who is harmed by an incident and a person who's responsible for the incident can get together in a justice mediation, which is administered by the same organisation essentially, and it's voluntary and it's confidential. It's essentially a diversionary program for adult criminal law offenders. But it's not just drugs, it's anything. And it's based on restorative justice principles. Look, it might be an opportunity for parties to repair the damage caused through criminal law activity, which is fueled by alcohol, for example, where the person who perpetrated the crime is now very sorry for what he or she has done. And it might be relevant for family members. So it might be something that you would encourage a client to undertake or consider in those circumstances, either the victim or the perpetrator. So it's administered through the dispute resolution centres in many parts, but not all parts of Queensland. It's not available, for example, where I am in Hervey Bay. So I've made the point in the past that that means that the people who are charged with certain offences in Hervey Bay simply don't have an option that is available to people charged with the same offence in Brisbane. But it could be a very useful procedure where family or friends are involved. You can imagine a couple of footy mates, they get into a stouch, the police want to get involved, they want to lay charges, but they really just want to sort it out, and setting up a justice mediation might be a good way to deal with that particular situation. Or it could just be generally a good defence strategy. So it can happen through the courts, and even when the prosecution has commenced, the courts can make a referral to justice mediation pursuant to sections 53A or section 88(1)(b) of the Justices Act 1886. And it's quite, the range of matters that can go to justice mediation is actually really quite broad. So it could be bodily harm, or it could be stealing as a servant, could even be sexual assault. Okay, any questions about diversions to justice mediation as an ADR strategy? Okay, we're down to two last ones. Domestic violence. In domestic violence court, which is closed court, if an application is sought, then if you're acting for the respondent, for the alleged perpetrator, if you like, you may push for a court referral to mediation. And if the matter goes to mediation, then in many instances, the matter will result in an agreement, and as a result of that, the parties may agree essentially to withdraw, or the aggrieved person may essentially agree to withdraw the application for a domestic violence order. It's a little bit like justice mediation, but justice mediation relates to a crime. Domestic violence can occur independently of a crime. In other words, if it's harassment or intimidation, that in itself may not be a crime, but it might be domestic violence, if you understand the distinction. And of course, a domestic violence order can be sought in conjunction with criminal prosecution. So in relation to, for example, an assault matter involving one party to a relationship on the other, that perpetrator can at the same time be subject to criminal law proceedings, have to appear on Friday, and be subject to an application for a domestic violence order, have to appear on Tuesday. Different jurisdictions in relation to the same incident. So mediation can be a consideration in that regard as well. And finally, peace and good behaviour applications, kind of a little bit like domestic violence, but peace and good behaviour applications are brought by people that aren't people who are in a relationship which would potentially enliven the jurisdiction of the domestic violence legislation and courts. So, for example, if you have neighbours and they're just not getting on, and one wants to restrain the other, it might be an application for a peace and good behaviour order, and that might be something which can be referred to mediation for resolution as well. Okay, well, I've been doing a lot of talking. I hope that hasn't been too rushed. I'm looking around, nobody seems to have terribly quizzical face. Has anyone come up with any new, different brainstorming alternatives? Okay, so Forbes has come up with them. In industrial, not totally new, but each side submits final offer and the whole of one is adopted. It's not mediation, but it's a good option. Thank you very much, Forbes. So it's kind of a setting out, here is the parameter. Did you want to explain that any further, Forbes? I may not have explained that and done it justice.
Yes, John. This is going back a bit in industrial situations, employer union, where they're very far apart in their negotiations. So you have an independent, say, arbitrator. Each side submits offer, and this situation forces them to be more reasonable because the whole of one offer will be adopted. They agree to that. So it stops the wild demands from either side.
Thank you very much. That's very interesting.
Yeah, I don't know if it was ever widely adopted. This goes back to the early 80s.
Are there any questions of Forbes in relation to that model? Okay. Thank you very much, Forbes. Appreciate that. Okay, so we've had some contributions from a couple of you in terms of different models that may be relevant. Think about that, and you might come up with something for the take-home examination. Speaking of which, I'll release that on Sunday. I think you've got a good idea of the parameters. I'm looking for something that's very practical, and one that an answer that hopefully provides an option or a range of options to a client or clients in a difficult circumstance. Are there any questions about the examination?
When is it due, John?
I'd have to look up. I think it's Thursday from memory. Just looking to see.
End of the day or midday? 9
usually 11:45 p.m. is my usual time for submission. Yep. Upload your work through Moodle in the usual manner, and it must be presented by the 8th of October at 11:45 p.m. Now, there's a bit of a difference here. I'm glad you raised it. I won't accept any late submission. If it's late, then it's a 0 mark. So if you're really worried about storm surges, or you're worried about whether you may not be terribly well on the 8th of October in the evening, well, the easy solution is just submit it early. But you may have some difficulty with me. I think you all know I'm pretty tough with extension applications. You may have some difficulty if you tell me that you weren't well on the 8th. The response might be, well, were you pretty good on the 7th and the 6th? If so, you should have submitted then. Part of it is, of course, that this is meant to be something like a real-life scenario. And in real-life scenarios, you just got to get it done. Yeah, sorry, Audrey.
Oh, I was just thinking about the time frame. With regards to a lot of the other take-home papers, it's 24 hours. It's very strict. The window seems quite generous. I'm just wondering if you're expecting that it is going to need to be done over the full 5 days, or is it something that if you sat down and looked at for a couple of hours, you could move it on?
Yeah, no, that's a really good question. It is a very generous window, and part of the reason it's generous is we have a public holiday in Queensland on Monday. So because I want to encourage contact with real-life providers, you may need to have contact on the Tuesday, etc. But you don't have to. That's just an option. And you should easily be able to complete this task within a day. So if you wanted to, you could have this finished and submitted on Sunday night and then go on to do something else. So don't feel as though it requires you to spend 5 days on it. Not at all. It is a 3,000 word limit. And question here from Grant, do we tell the ADR people we contact that it's a fake scenario? Yeah, look, I would be upfront with them and say, you're doing this for an examination. Would you mind helping? Understand if you aren't prepared to help, but I would be grateful. I suspect that they might be interested in talking with you, because if you're a law student and you've got an interest in ADR, they may see you as a prospective client next year or the year after. So hopefully they'll be prepared to contact you. Now, in case you're wondering, no, please don't contact me. I am a nationally accredited mediator, but I'm not going to give you any information or help. So that you just came in with that. Catherine asked that question as I was answering it. So thank you. Nice try. All right. So are there any, with the word limits, I don't mind if you attach something that won't count. So if you receive some sort of overall proposal from a supplier, pop that as an attachment, that's fine. That won't count towards your word count. And you don't have to go to 3,000 words. If you have all the material in 1,000 words, that's fine. 3,000 is something that is being phased out. I don't think you'll see too many of those very long assignments into the future. Okay, well, thank you for those questions. Yes, Audrey?
Yeah, I'm just wondering if there's going to be any feedback, or not generally with the end of exam, end term assessment.
I haven't conducted a take-home examination before. It's my understanding that there won't be feedback on this occasion. There might be some generalised feedback, but I think the model for the university is that a take-home exam is similar to a sit-down exam in that there's no feedback. Does anyone have any experience to the contrary? That'll be a no? Okay.
No, normally we've just had
feedback and not individual.
Yeah, what Cassie said.
Right, generalised feedback. Okay, so thank you very much for that and giving me an idea as to what to do there. Okay, well I think, so there won't be a session next week. That means we're almost at a close. Thank you very much for doing this course. I really appreciate it. Does anyone want to take me on in a typing challenge? Brad's looking as though he's not interested. He's not going to come in on that.
Not even with my new fancy dragon voice software. No.
All right. Thank you, Brad. All right. Well, that's great because I remain undefeated in ADR in typing as a result. I haven't beaten anyone, but I remain undefeated. I'll look at it that way. Okay. Well, thank you very much for your participation, everyone. And I look forward to watching the discussions in UCrew over the next week or so, and all the very best. So I'll stop the recording now. Thank you.